Hello, I'm professional attorney and very much amateur musician Scott Lesowitz, and Mary Spender released a video on how it works posting cover songs on YouTube and how music publishers will claim some or all or virtually all of the revenue through YouTube's Content ID system. Now, she discussed copyright law in the video, and she did a great job. And she sounded way more British than I would doing so. So I'm not here to correct her. I just want to elaborate on a few points that Mary made. So the biggest issue is that there's a lot of confusion about cover songs on YouTube because under the copyright law, there's a compulsory licensing or statutory licensing system that allows musicians to legally cover any song that's been previously released as long as they follow the procedures and pay a royalty amount set by law to the copyright owner of the song, even if the copyright owner does not want the musician to cover the song, they cannot stop it. This is really unique in copyright law. There's no other area of copyright law where someone is forced to allow someone else to license their copyrighted material. The problem here is that the compulsory licensing system only covers use in sound recordings. The compulsory license does not extend to what are called audiovisual works. And when someone releases a YouTube video that contains visual images of them playing the song, like a regular cover video on YouTube, that's an audiovisual work. So some of you might be thinking, but there are plenty of famous music videos of cover songs. Well, that's correct, but that means that the person covering the song had to make a deal to obtain permission from the songwriter, whoever owns the rights, to the musical composition and be allowed to use it. And that's what's called a synchronization license or a sync license, where someone obtains the right to synchronize the music with the moving images in the video. So if you make a cover of a song on YouTube and have a regular video with moving images, that's an audio-visual work, and you're going to need a sync license. You're going to need permission from whoever owns the rights. You cannot use the compulsory or statutory licensing scheme. Now, that said, a lot of big owners or administrators of copyrighted music have entered into deals or have decided to allow songs to be covered or used on YouTube, and then they take a chunk, really whatever they want, through the Content ID system. And so Mary had, for instance, I think it was Sultans of Swing, they took around half, whereas other songs, they were taking closer to 100%. And in my personal experience, it's usually closer to 100%. Now, another issue that Mary touched upon is that with songs in general, or copyrighted songs that have been recorded, there are actually two copyrights in the song. One is the musical works copyright, and the other is the copyright in the sound recording. So the musical work copyright is in basically everything other than the sound recording. It covers the melody, the rhythm, the lyrics, those kind of things. And the sound recording copyright only covers the one particular recording of the song, as well as any copies made of that recording. So therefore, when there's a cover song, the only copyright holder that really is involved at all is the one who owns the musical work copyright. So with that, hopefully I helped provide some additional context and clarity to Mary's, once again, very good video. And with that, thank you and take care.